Cool. Can everybody see that? Awesome. So I wanted to start with, and there's not this presentation. I've given presentations on the juvenile justice system or the juvenile court system, sometimes even just because we know words matter. Often the shorthand is juvenile justice system, but that also sort of supposes that there's justice being delivered by the system, and we can certainly question that. So I'll probably just out of sheer habit default to that, but I am aware that it might be most appropriate to talk about the juvenile court system or the criminal court system rather than a justice system. But like I said, I have given these presentations before. We could talk easily for an hour and a half just on sort of the details of the juvenile court system. I know we don't have that kind of time, so I'm going to try to hit the points that I think are kind of most relevant and important in distinguishing. I know you guys have spent a fair amount of time talking about the criminal court system and how it impacts adults and the various dimensions of the criminal court system. And I spent a long time working with it in the adult system as well. So I feel like this is kind of an opportunity to talk about the ways in which the adult and the juvenile system are both similar and different. First of all, the stated goals are different. Now, I should say that technically the stated goals of the adult system are broader than punishment. Folks that work prosecuting those cases, I'm sure would disagree that the main focus in the adult system is punishment, but retribution and punishment is something that is anticipated and contemplated in the adult system in a way that it isn't at least supposed to be or isn't stated as a goal in the juvenile system. The idea, the sort of founding philosophy of the juvenile court system is a focus on rehabilitation and best interests of the children. The best interest standard tends to come in more robustly in child welfare cases. The juvenile court system doesn't use it in exactly the same way, but that does come up a lot. It's helpful in the juvenile system that at least the stated goal is rehabilitation and restoring a youth to law-abiding conduct and getting them the services that they need to be successful. Even though I don't think that the juvenile court system lives up to that goal all the time. And I think often the consequences that are imposed in that system are thinly veiled attempts at punishment, but at least the fact that there is some sort of intentionality around trying to achieve rehabilitation rather than just straight punishment is useful to know. A lot of the processes of the adult and the juvenile system are similar. So the fact that you've spent some time learning about, prosecutorial discretion and other aspects of the way that adult cases are brought and prosecuted is useful here. In an adult case, the county attorney will file a complaint. In a juvenile case, they file a petition. They're essentially interchangeable. They list the offense that is alleged to have been violated, the statute number, and then the facts that support their claim that a law has been broken. That's a probable cause statement, whether it's a complaint or a petition. And so whether or not the facts that are alleged in the petition establish probable cause, we can challenge probable cause in juvenile court the same way that we can in adult court. In adult court, folks are referred to as the defendant. In juvenile court, they're referred to as either the juvenile or the respondent. Again, it's just a semantic difference. If someone, in some ways, this is, I think, maddening, because when I'm trying to explain things, the juvenile court system is confusing as heck, period. And when you're working with juveniles, you already have, youth who have no reason to have any basis of knowledge for the system anyway. And so why we have, as a court system or attorneys, decided that everything has to be renamed is super annoying. We do this a lot as lawyers. Why we can't just use plain English is something that continues to elude me. But what people most normally think of is like, okay, you've been convicted, meaning that a judge, and in a juvenile case, it is a judge. There's no right to a jury trial like there is in adult court. That's a difference. So where a judge finds that, yes, the prosecutor has proven this case beyond a reasonable doubt, In a juvenile case, that person is not convicted of the offense, they're adjudicated of the offense. And adjudication is just a really, it's one of those words that like you kind of, even after you've been through law school, you're like, I mean, I kind of know what it means. It basically means like the entry of judgment. But I use, when I talk with juveniles, I'm most often using conviction because that's like a normal word that people understand. They're like, okay, I'm found guilty. Like it's going to go on my record. It's going to be a thing. Adjudication is basically just this, has the same effect. And then the same thing in an adult court, we'd say, okay, now you've been convicted, you're going to get a sentence. What is the sentence going to be? That could have a number of different terms. In juvenile court, we say a disposition. How, like literally, how are we going to dispose of the case? And so there'll be like a dispositional hearing, but that language, again, those things are interchangeable. So if you hear some of that, like I said, why we have to have different words for it, I don't know, but that's the language that we use in juvenile court. One thing that is different and tracks back to the stated goal of rehabilitation is in adult, you probably, if you come to some of the prior teach-ins, talked about sentencing. And I know we talked, LRC put out a lot of information around sentencing in the context of the Chauvin trial. In adult cases, there's determinate time-based sentencing. If you were paying attention at all during the Chauvin case, you knew that like the presumptives about the sentencing guidelines, presumptive sentences, then upward and downward departures, and all of that came into play when we were when the court was determining how they were going to sentence Chauvin. That none of that applies in juvenile court. None of the sentencing guidelines apply to juvenile cases. There is no determinate sentencing in juvenile court, regardless of the offense, if you are in juvenile court. And we'll talk about how a person who is age-wise a juvenile may end up in a different court. But if you're in juvenile court, there's no determinate sentencing. And so what that means is that if a youth is sent to, say, Red Wing, which is the juvenile prison in Minnesota, they are sent there, even though it is a completely secure facility that is a jail, a prison in basically all meaningful respects, they are not sent there for a certain length of time. They're sent there to complete programming. And this is both, the idea behind it is that because we're not punishing this person, we're not sending them to prison for a certain amount of time to punish them. We're sending them to programming. And so once they've completed the programming, then they can be released. What's frustrating about that is that I can't tell my clients how long they're going to be in Red Wing. And it's very subject to who their case managers are, whether or not they're beyond Red Wing. Most secure facilities, treatment facilities work in terms of levels when you're talking about juveniles. That's true for all different kinds of out-of-home placements, but usually a kid lands in a program of whatever sort of variety, but this is true at Red Wing, the most secure of our juvenile facilities. And they say, okay, you're going to start at level 1. And when you've gotten to when you get to level 4 or 5, whichever, depending on the facility, usually at Red Wing, it's level 4, then we have determined that you've completed the programming and now you're ready to move on to potentially be discharged. How long it's going to take you to complete the program depends on you. And, so like I say that sort of facetiously because actually it really depends a lot on the case managers and the program and the expectations and the ability to meet those expectations, all of which is vastly more complicated. And sometimes I have kids, much like I had adult clients, who would be like, I don't want to do this programming. I just like, so tell me I got to sit here for 6 months. I'll sit here for 6 months and I'll leave. Adults can do that. They don't have, as long as they're not affirmatively causing additional harm where they're picking up new charges in prison, they can sit and do nothing if they want to. Juveniles can't, or they can. And I think the reason for that, another reason, like I said, they tie this to the fact that they want there to be this completion of programming. But the reality also is that the juvenile system will lose jurisdiction by the time a youth is 19. So unlike an adult where you could spend your natural life in prison potentially, there is a hard stop in juvenile court, and so that makes it a little better, but still kind of I think that's an interesting point of debate. Like, do we like that there's not determinate sentencing? There's pros and cons to that. The other thing that's unique about juvenile cases that is different from adults is if I commit a crime in Hennepin County, I will go through the entire process. In fact, we saw this with Chauvin, right? He committed a crime in Hennepin County. His trial was in Hennepin County. His sentencing was in Hennepin County, even though he lived in Oak Park Heights or Oakdale or one of those Oak suburbs. That is not in Hennepin County. So, but that didn't matter. Where he lived didn't matter. It was grounded entirely in where the offense took place. For juveniles, if I commit a crime in Hennepin County, I will go to Hennepin County to answer for the offense. But if I get to disposition, sentencing, I'm going to go back to my home county. I'll come back to Ramsey County. And that also, the idea of that is that, again, because there's this anticipation that there's going to be programming. Whereas like with a case like Chauvin or other adult cases, if you're going to prison, we have a whole statewide system of prison. It doesn't really matter if you came from Hennepin or you came from Stearns County, you're going to start at St. Cloud and you're going to get farmed out from there. Juvenile cases aren't like that. The idea is that you're going to be in your county of residence. And so that county needs to provide the supports and services. And that's why cases get transferred back to a home county. Again, potentially a good thing. It makes some sense why we do that, but it makes it a lot more difficult for me to work out negotiations in the county that the case is charged in, because I can say like, well, I think when you go back to Ramsey, it'll be like this, or I think this is what will happen, but Hennepin can't actually bind Ramsey County or any other county. And so it again is another point of uncertainty. And it kind of feeds into that whole idea of like, well, everybody's going to act for the best interests and do what's sort of rehabilitative for this kid. And so we don't need so many rules. And, maybe that's true, maybe that's not. I'm not going to spend any significant time on this, but it's just useful, I think, to know that the laws are basically the same. So what a juvenile can be charged with is grounded in the same laws that adults are being charged with. That's chapter 690. Of course, we have drug laws in different chapters across the Minnesota statutes, but our primary criminal chapter is 690. Juveniles can be charged with petty misdemeanors, which is that lowest level misdemeanor, gross misdemeanor, and then up to felonies. So that is all the same sort of structure as adults. There are adult procedural rules that govern adult court. There is a whole different set of juvenile delinquency procedure rules that govern in juvenile court. That's more relevant if you're going to actually represent kids. It's less for sort of just general understanding. Charging and detention procedures are similar, which means that police take reports, they send them to the county attorney makes decisions about whether or not they're going to charge someone. The police also have that discretion to determine whether or not they're going to just issue a ticket. They might send a citation after the fact, or if they're going to actually go and arrest somebody, engage in like a search of their person or of their car or of their house. All of those same constitutional protections apply to juveniles in the same way. If they're detained, the review status is similar, where they have to get in front of a judge to consider whether or not they can continue to be held in custody, whether or not that probable cause standard has been met to continue to hold them. Speedy trial demands are the same. So a lot of those constitutional protections do apply to juveniles in the same basic way that they apply to adults. Attorney-client privilege also applies to juveniles. And what that means is that when I am representing a juvenile, the juvenile is my client. I am forming an attorney-client relationship between myself and the juvenile, not their parents, not their caregivers, not their older brother, not their auntie, not whoever else. The relationship is between me and the client, which means that it is my responsibility to make sure that I have a functional relationship with the juvenile. It's my job to make sure that I don't care if their parents understand what's going on. That might be nice. And because of the way that I practice, I think that there's a lot of general information that can be provided to caring adults around a kid if the kid gives me permission to talk to caring adults around them. But ultimately, it is the juvenile's decision whether or not they want me to share anything at all about the case, and sort of how much they would want me to share. If there are things that are really specific to the offense charge itself, that is something that I will talk to my client about individually, because attorney-client privilege can be breached by the presence of other people who don't share that privilege. This can be a tricky thing for parents, especially, to understand. And I get it, because I'm a parent and you're like, I'm responsible for this kid in every other way. So yeah, it's nice that like this relationship is between the two of you, but I'm the one who's ultimately, it can feel a lot like I'm gonna have to pay this restitution. I'm the one who's got to get him to court. I'm the one who's got to get him to programming. So I am very upfront at the very, very beginning of meetings. And I talk a lot about the court process first, which doesn't implicate anything specific to any client, to make sure that parents and caregivers can get their questions, their general questions answered. And then, but right away from the beginning, I'm explaining that the juvenile is my client, because ultimately, as we proceed with the case, a parent and a kid might have different, may come to ultimately different conclusions. A parent might say like, screw this, man, we're going to trial. And a kid might be like, I don't want to do this for whatever reason. And they might tell me like, I want to take that plea deal. If there is a disagreement between a parent and a child, I do what my client wants to do. It's my job to make sure my client understands what the options are. But if my client says, I want to take the plea and the parent wants to go to trial, I will be taking the plea because it is the juvenile's my client. So I kind of alluded to the fact that there are different types of cases that involve kids that are under 18. Juvenile delinquency, extended jurisdiction juvenile, and then certification to adult court. And we'll kind of touch on each of those. One thing that I think a lot of people don't realize is that kids can be charged as young as 10 in Minnesota. If a juvenile is charged in delinquency court, they can stay under the supervision or control of the delinquency court until they turn 19. If they commit an offense after they turn 18, they're going to be charged in adult court. But if they were under 18 at the time of the offense, the court can keep some supervision over them until they are 19. At the time they turn 19, though, that jurisdiction evaporates. And regardless of sort of what they have done or not done or completed or not completed, the court loses jurisdiction and they are done with coming to court on that particular charge or offense, however it was resolved. Records are generally sealed and confidential unless the youth is 16 or older and charged with a felony. Then those records are just flatly public, which a lot of people don't know. And also, sealed and confidential does not mean they can never be used by anyone. It means that your neighbor can't go down and look you up and find these records, but they can be used to have employment consequences. And that's a whole other presentation that we give on collateral consequences. But it's important to know that juvenile records are not necessarily as completely private as people assume that they are. Extended jurisdiction juvenile, or this EJJ abbreviation, which you might hear from time to time, is a hybrid between staying in juvenile court and going to adult court. It can't be done automatically. Usually the prosecutor has to ask to say, I want this to be an EJJ case. What that means is that the case is sort of like the very last chance, and it's a carrot and stick approach. So the carrot is, hey, we're going to maybe let you stay in juvenile court. You're going to have a juvenile disposition imposed, which means you're not in the adult prison system. And your case can potentially stay in juvenile court in exchange for extending the court's jurisdiction over the youth until they're 21. So as I just said, like usually that expires when they're 19. If you're EJJ, it doesn't expire until a youth is 21, and there is an adult sentence hanging over their head. So they don't have to serve that adult sentence, but it's basically like, here's your last chance. Go on juvenile probation, go do these things that we've asked as conditions. That's probably some residential time and then probationary time. Depends, of course, on like the nature of the offense and all of that. These are all there's sort of no absolute general thing I could say about any particular offense. If you successfully complete that probation, all the terms that we asked for, your case stays in juvenile court, you don't end up with an adult conviction, and you don't have any time in the adult prison system. But if you fail, you will come back, and then you will automatically already have this adult conviction, and you could potentially have to serve this adult sentence that we've imposed and stayed, which just means paused. And then the most serious, of course, is adult certification. So youth who are under 18 can be certified to stand trial in adult court. The minimum age for that is 14, which is unbelievable. There are different ways that cases can get to adult court. And this is all governed by statute. There's a permissive where the court can grant permission to the prosecutor to move the case to adult court, where there needs to be a hearing and the court finds that public safety will not be served by retaining the case in juvenile court. Or there's presumptive, which means that if you are 16 or 17, this offense would be an adult commit, or you used a firearm during the commission of the offense, then we're going to presume you're going to adult court. That's rebuttable, which means as the attorney for the juvenile, you can say, no, I want to explain to you why this case should stay in juvenile court. But if it's presumptive, that is more difficult, because the idea is that the legislature has already decided that in these sorts of situations, we assume going to adult court is the right place to go. Obviously, that is very serious. The certification, there's a whole hearing that is often very much like a trial. And there are a number of different standards that need to be met in order to determine whether or not a case is going to go to adult court. Because if a case is in adult court, then the sentence, I had a number when I was an appellate public defender, I had probably 5 or 6 different cases where juveniles had been certified to adult court and were serving life sentences. So the consequences of that, obviously those were very serious offenses, but can be very extreme. So things that I think people don't necessarily realize about juvenile, sort of how juveniles interact with the court system. One thing that I emphasize in every forum that I ever am able to be in front of with anyone is that, because I think people do not understand this from my experience talking with all sorts of different kinds of folks, is that juveniles have a right to an attorney. They do not have a right to a parent or a caregiver being present or knowing that police are talking to the juvenile. And parents are shocked by this over and over and over again. It is perfectly legal and not a constitutional violation for a police officer who is dressed like me, maybe looks like me, to show up at a school, pull a kid out of class, and say very, in passing, like, hey, I'm a cop, but, we just need to talk about that thing that happened last week. The juveniles do need to be given Miranda warnings. Those are the warnings, you probably talked about them before. You have a right to remain silent. Anything you say can be used against you. You have the right to an attorney. If you don't have an attorney, one will be appointed for you. That is the only warning a 12-year-old might get before having to talk to the police. And if they say, I really want to call my mom, I really want to call my auntie, I really I don't know what's going on here, the cops are completely within their rights to say, yeah, we'll call her. Yep, we're gonna get to that. First, we need to talk though. Let's talk about this first. I won't, as an attorney, I will not be able to do anything about that because the cops did not violate any constitutional protections in doing that. This is true regardless of age. And that, like I said, you can interview youth basically anywhere the cops can find them, at the community center, at the Y, at school, wherever. And there's no need to call parents first to say, hey, just a heads up, I'm going to go talk to your kid. And there's no obligation for police to involve parents. This is why, and I feel like this is one of the things that this bothers me so much, because I think it is so counterintuitive to expect any kid to think, oh, what I should ask for in this situation is a lawyer. Because most kids have they have the most abstract concept of what a lawyer is. Most of them don't have any particular relationship. Most adults don't have a particular relationship with a lawyer. I always kind of liken it to, like, if somebody told me that, like, I could call an astronaut, I'd be like, do I know what an astronaut is? Like, kinda. Do I know any? No. Do I have any idea how I would find one? No. Do I it's just so absurd. You're like, how would I, what? So that's not who kids ask for. Why would a kid ask for an attorney when they have no concept for what that would be or how it could help them or how that would ever even come to pass in their day? They ask for their parent, they ask for their caregiver, and that's super normal and super developmentally appropriate, and it won't get them the protection that I want them to have to not say things that will incriminate them. As Malika mentioned, or Lupita, I think in my introduction, I do a lot of work with cases that are involved with child protective services. That is a whole other presentation, and I'm already over time, which I knew I would be. So I am not going to talk about that specifically, but I do want people to know in the context of juvenile cases that oftentimes as attorneys, as I had mentioned, with the need to make sure that my client is understanding what I'm trying to tell them about their rights and about the case, sometimes kids are just too young to understand anything about the system. And it's perfectly natural and normal and developmentally appropriate that they don't understand. But then what I might do is ask for a competency determination. And that just means that like a forensic psychologist will evaluate this youth and determine whether or not they are able to participate meaningfully in their defense. What ends up happening though, if a kid comes back incompetent, which is often just a function of age, it's not that they're permanently not able to participate in their defense. Then what will usually happen is that if their case is paused because they're not competent, a child protection case will open. That's the way the county attorney's office tends to handle it, at least in Hennepin. And that can create a real tension because I'm representing the juvenile. I don't want this kid to say anything. Like, they don't even understand what's really going on in their case. They certainly shouldn't be engaging in treatment where they might make incriminating comments or participating in things that child protective services might want them to participate in. I can't advise their parents because their parents are not my client. So it gets complicated really quickly in terms of like, and parents then get very stressed because they get CPS cases opened on them when there's no other allegation that anything, unhealthy is going on in the family. There's not an allegation of like abuse or neglect or any of that kind of thing. It's literally just like, hey, there's this kid that we want to do stuff because we have concerns about them, even though that stuff hasn't been proven. And so we'll kind of, circumvent this and go to the parents and try to get the parents to compel the kid to do things. So that I think can be very problematic. And then, like, again, I could spend literally an hour talking about crossover youth. So kids that are in foster care and then may pick up juvenile charges. That's certainly that occurs. And those kids often will spend longer times in custody because there's no place for them to go. Because they don't have a family that they could immediately be discharged to. A lot of foster homes are like, nope, if they've got juvenile charges, I don't want them. Other residential facilities might not be available. So even though a similarly situated juvenile with a family would be able to leave detention, they might not be able to. And there are also just fewer resources to like having the ability to have a family that can accomplish some of the community services that prosecutors or counties might want. It's something that for kids that are also not to even touch on the fact that like this very significant trauma histories that almost every kid that's in foster care has experienced means that they need deeper and more robust services. So just to be aware that this is a very important area to think about, and those are youth that we should all be concerned about because they are often coming into a juvenile court system for manifestations of mental health and trauma, as are frankly most kids, whether they're in the foster care system or not. One of the things that I think people don't realize, and that actually even surprised me before I was doing juvenile work on a regular basis, was that sometimes parents or caregivers actually instigate system involvement. And they may do that intentionally. And that where I see that happen is when parents and caregivers feel like a kid is out of control and endangering themselves or others, and the family has reached out to try to get support or services, and it hasn't been forthcoming in any way. And so then sort of at the very end, like there's this sort of societal narrative of like, well, maybe, whether it's the scared straight or maybe what I just got to get get them involved in the system, and that's going to be the end of the line, and that's going to finally have an impact. And what I can say conclusively is that I have never seen the involvement of the juvenile court system to actually provide the meaningful supports and services that families actually want for their kids. But sometimes parents are so desperate that they feel like that's the only other place that they can turn to. And then they get wheels in motion, like calling police to resolve like a home conflict. There's a number of juveniles that are charged with domestic assaults because of fights that happen in the family. And so from my perspective, all of that situation just says like we as a society have not provided the kinds of mental health and family dynamic support resources that we need to, because the juvenile court system is not designed or intended to provide the kinds of supports and services people are asking for it. And that's kind of a crossover point where I know that folks I'm sure in these teach-ins have talked about, are there alternatives to calling the police, whether that's for adults or for juveniles? Like, we need as many as possible. And then they can unintentionally involve the court system too, by like having a belief that, hey, you should just tell this, talk to the cops. You probably didn't do anything wrong. This was your friend. I hated that kid from the beginning. Go tell him what happened. And that can sometimes work very much against a kid's best interests, because the police know a lot more than they are ever saying in those conversations. And because parents may not be as well, or caregivers may not be as informed as we wish they were about sort of their rights and ways to use those rights, they can unintentionally involve a youth deeper in a system that they, I'm sure, do not want them to be involved in. As I mentioned, I think folks think that juvenile records are totally confidential. They are not. I don't know why my circle didn't show up there. That juvenile records are expunged once someone turns 18. Also not true. That's an affirmative process that, except for very limited circumstances, that kids need to go through to petition to have their records sealed. And that the only records that are kept are records of adjudications. This is also not true and really mind-boggling, but just the fact of having a charge, even if that charge is dismissed, can later result in collateral consequences primarily around employment. Like, certainly there are a number of different collateral consequences, but where I see that come up the most is around any sort of job that requires DHS licensure. And so DHS license all sorts of facilities that work with vulnerable people: hospitals, nursing homes, childcare, so that means even if you're washing dishes in a hospital, if you're the janitor in the nursing home, and you, when you were 14, were charged with a 5th-degree crim sex that got dismissed, you may not be able to have that job. In fact, it's quite likely you won't be able to have that job unless you get that, even just the charge, expunged. And people, I don't think, it seems amazing that that is the system that we have, but it is. And a lot of people don't know this until they get the letter saying, oh, you can't work there. And then it's a multi-month process to go through the expungement. And they haven't done that because they didn't even think that there was any reason that they needed to. So when sort of topics are thinking about ways that we as community members can get involved in this and care about these issues and push for juvenile justice, some ideas that I have, and I'm super interested to turn this into the conversation that I want it to be, not just me talking, to hear other people's ideas around supporting legislation to require parental presence during police questioning. I think we could also push for legislation around automatic expungement of certain juvenile records so that that burden is not, like, how about dismissed? I mean, there's so many like just low-hanging fruit. There might be some areas where there is a like potentially legitimate public safety reason to keep certain types of adjudications for perhaps a certain amount of time, but we are way too broad in what we're keeping and the burden that we're putting on juveniles to try to address their record. We could change that. Being trained, we do a lot of train the trainers at Legal Rights Center to talk about like know your rights, having as many people in the community know what their basic rights are in interacting with law enforcement so that they can make knowledgeable choices about how they themselves want to interact with law enforcement or how they'd want to advise youth that they care about to interact with law enforcement. Advocating for robust community-based mental health and chemical health supports and services. I'm on this soapbox all the time because there's just not enough. And it's not, we end up with like, oh, if you need something more than like therapy once a week, or you don't really want to get into the chemical dependency treatment program that we suggest for you, kids escalate quickly to like in secure or like inpatient residential facilities. And there is so much room, in my opinion, for much more robust services in the home that are really intended to shore up the relationships that youth already have and that are going to continue, rather than taking them out of their home and their community to provide services over here in the secure setting and then return them back. It doesn't make any, like, that just doesn't make any sense. And we know it doesn't work that well. And then supporting diverse school options so that youth have multiple pathways to success. I mean, that really, I didn't know what poem Emmanuel was going to read, but I think that charts right to that, which is that if there is only one way to be successful, if there's only one way to get through school, if there's only one vision for that, and we know that that's influenced deeply by like societal educational racism, among many other things, we are constantly setting up multiple kids for failure. And the more we can have a diverse pathways to success, different ways that kids can express themselves creatively, that they can find a home in a school setting, they can find supportive adults who care about who they are, rather than sort of, here's the model, and if you can't fit this model, you're out. We as adults can be asking for that. So that's what I got. I'm sorry I went over, Malika, but I did know I would.
Yay, thanks, Bridget. Well, we have a question already here in the chat, and if folks have other questions for Bridget, you can unmute yourself and ask or drop them in the chat as well. But I see that Michael put this question here that there in rural Carleton County, there is a restorative justice diversion program that works really great when it has a chance to. So what percentage of counties have restorative justice diversion? How's it funded? Do you see more like mainstream criminal justice funds going towards that?
Well, Malika is in a great position to answer this too. Yes, I do think that there is a lot of interest in restorative justice and diversion. We've seen that to great effect through the work that our executive director, Sarah Davis, and Malika have done around trying to expand that in counties with prosecutors to get cases referred for diversion. So that's happening in the metro area. I wish I was more knowledgeable about sort of what's going on across all of Minnesota. I'm glad to hear that it's happening in Carleton County as well. But I do think that there is interest in that, and we have seen some success. I don't know, you'd want to add to that, Malika?
Yeah, it's actually like one of the few successes at the legislature this year was the passage of a bill that authorizes all law enforcement across the state to start their own diversion programs if they so choose. What we had heard and what we've seen in different counties across the state is that very often diversion only is offered from the county attorney's office. So after a young person has already been charged, which to Bridget's point, already in that moment of charging induces a whole heap of long-term collateral consequences. So this bill passed allows diversion to happen in any county at the point of law enforcement contact, so like police diversion. Our work now that this bill has been passed is to like help answer this question that Michael has asked, which is like, okay, now what counties are doing it? What are the success rates that we're seeing? And I think that one of the challenges that we know across the state with regards to the youth justice system is just that we don't have good data. So no one in the state could tell you today how many young people are in a secure facility, how many young people were arrested today. And they could actually tell you those numbers for adults, but we don't do the work I think required to track it on the juvenile end. So that's certainly advocacy that I'm interested in. And I see that, yeah, Siobhan, if you wanted to even speak any more about like what the work that you do at Seward Longfellow Restorative Justice and how you've seen that play out, that'd be awesome. But not to put you on the spot.
So, oh, no problem. So I've been with Seward Longfellow since, let's see, maybe like a year and a half. I started as a volunteer, just trying to be helpful in the community. And then they created a position, so I'm the referral coordinator. And we've done things in the schools. We have the community contact us. It's been really great. Since COVID happened, I think I've maybe had one conference, one or two, and Seward Longfellow Restorative Justice was primarily for youth. It was founded by the community and it was for youth. And since COVID, we haven't really had any referrals for youth. I don't know if that's good or bad, but I've worked on it. Now it's kind of just like whoever reaches out to us, whether it's youth or not, we're going to help if we can. I worked on a couple actual adult cases recently. But again, really nothing much has been happening. But most of our funding comes from donations. Most of our referrals come from the county attorney's office. And I was actually on a call with Mayor Fry maybe like a month or so ago. And, he said he was like all for it and all those good things, but never anything about funding. Like that question, it was brought up, but he didn't address it at all. So I heard that there's a ton of money out there that needs to be spent on public safety and all those things. And people mention restorative justice. They talk about how great it is, but they just don't, push the funding. I spent I would say about 20 hours on a case for an incident that happened at 38th in Chicago. And I think, I don't know who all is involved at the county level or the city level, but I did this on my own with a team of volunteers. And so I'm sure I saved a lot of money, right? It's fine, it's great. But the point is that, they're spending a lot of money and resources on this, right? When they could be, referring children or, just people in general to restorative justice for these low level crimes. And, it's about repairing the harm. It's not about, punishment. So I don't know if you guys have any questions, but that's kind of my 2 cents.
Yeah, thanks, Siobhan. Any other questions for Bridget specifically? Otherwise, we'll just move into our breakout rooms to kind of talk through all of the fantastic information that Bridget shared. But any other? Yeah, Nicole, hey.
Yeah, Bridget, I do have a question. You said sometimes youth they have to go for a referral to a forensic psychologist if they're deemed not competent. Is that forensic psychologist, is that through the county or where does that psychologist come from? Or is that someone they just use, or does it vary?
Yeah, usually it goes, there's every judicial district has court services, and they have a team of forensic psychologists that basically work for court services. And so if I go into court and say hey, I have concerns about the competency for my client, I'd like to request a competency eval. I can't just say oh, I'd like to use a psychologist in the community, maybe that this person has known. What will happen is the court might grant that, but it would get assigned to this court appointed. There's this presumption then of neutrality, so it's sort of, there may be, and actually this just came up, a question from another attorney that works in St. Paul, whether or not there's any wiggle room to not use the court appointed psychologist. And, especially for a youth that maybe is working already with a psychologist, that might, in my opinion, that would be better because they would have deeper knowledge of the youth. I don't know, I know that we've got one other juvenile attorney that's at least one, and there may be other folks I don't know that are here today. And so if anybody else has any more information about, I have never had any success using a non-court appointed forensic psychologist, but it's possible that could happen, and potentially in another county too.
Okay, thank you.
Okay. Well, let's keep the combo going in some breakout rooms. You'll see an invitation into a room in just a second, and I'll stop the recording at that point so that you can have the discussion that you choose. I just want to quickly share a couple of discussion guidelines, and then we'll spend about 20 minutes in that breakout room. Let me just make sure that I have the right screen up here. But, you know, we're asking for folks to like engage in this discussion as much as you choose and to do it in a respectful way. So, you know, treating people as you would treat them in real life, being tolerant of other viewpoints. We want to have a robust discussion, but also want to be, create a space that feels safe for everyone to share their perspectives. A couple of other things here, if you want to turn on your camera, you're welcome to, but if you're not, that's fine. Keeping yourself on mute if you're not speaking is also very helpful, and using the chat as an additional conversation piece, but maybe not to be distracting. And then we ask that you respect the privacy of the folks here, that people might be sharing personal experiences that they don't want to leave this space, and that you might be speaking of a general practice that might be directly impacting someone who's in the room. So with that, we'll go ahead into those breakout rooms, and we will come back together as a whole group around 6:50 or so.